show why we should suspend and why this tribunal does not have this authority. And my colleague will show that the claimant's submissions were valid. And I would like to remind this tribunal that the on-its-face standard of Article 14 of the UCP applies only to issuing banks and in no way limits this tribunal, and therefore the burden of proof is on the respondent to show why this tribunal cannot assess the validity of the act. And I've shown this tribunal that there was consent to arbitrate on behalf of the bank, that this proceeding should not be suspended because the test mandated by the ILA is not met here, and that this tribunal can determine, if necessary, the validity of the acceptance act and amount to be finally paid to the claimant. I would like to stress to this tribunal what this case comes down to. Promises must be kept. The respondent bank, a sophisticated party, made a promise in which it expressly chose to make part of the letter of credit a reference to the arbitration clause in the shipbuilding contract. And it is now trying to avoid fulfilling its obligations. So, Mr. Chairman, if there are not any further questions regarding consent, suspension, or the ability of this tribunal to determine the validity of this act, that closes my submissions.
Yes. If in the other proceedings a determination is made which says no further payments are required to be to the yard. In this case, then there's a determination which is made that payment needs to be made under the LC. Then couldn't we be facing a situation where no further payments are made under the yard, but nevertheless, the award is granted to pay $11 million to the party which is not entitled to it.
So to clarify, you're stating that in the other arbitration, it's determined that the damages that the buyer is seeking it's not entitled. The buyer has no right to those damages.
No. In the other determination, because there's a counterclaim, I understand. There's two claims from buyer and the seller. And the tribunal would say, yes, from one side, the buyer owes some money to the table, to you. From the other side, because of some deficiency in construction of the yard. Because damages for which you are liable, and the buyer offset the debt to you against the damages, then the tribunal's other arbitration will come to the conclusion that you have right to zero claim. And despite of this determination, in this arbitration, if we award you your claim, you will still be entitled to get $11 million from the bank, while the other tribunal will decide that you're entitled to zero.
So just to clarify, you're saying that if the buyer wins on the proceeding, what would happen in potential offsets?
Well, will it be a situation where you will be granted something for which you are not entitled?
So two responses to that question. One is, I think that there are a lot of possibilities of how different outcomes can happen. I think this tribunal should concern itself on determinations that have happened. So if there's a final award, this is something that we might consider. But what I would point to is that dispute, as I've stated in my argument, is about breaches under the shipbuilding contract. And so if the buyer is awarded, hypothetically, $18 million there, my client, the claimant, is definitely entitled to pursue a claim under this letter of credit because it made a compliance submission and is entitled to payment. So regardless of potential offset scenarios, we would submit that that's not under the purview of the tribunal as constituted there, because their job is to just understand breaches of the shipbuilding, not the letter of credit.
I would claim the same amount twice. With another arbitration as remaining part of the claim, here as payment under the suit.
As written, the claimant has not made a counterclaim of that proceeding.
Okay.
That's the reason why it filed this arbitration under the terms of the letter.
Okay. My other question with regard to determination of acceptance. So, in essence, you are saying we have jurisdiction to decide whether acceptance was validly signed by the buyer or not. And if we decide that it was validly signed or was not validly signed, we're deciding on the rights and obligation of the buyer. while buyer is not a party to this arbitration.
I would disagree with that characterization. I would respond in two ways. I think first that I'm submitting that it's not even necessary for this tribunal to even consider the validity, because if it makes a determination that the bank had made a final determination, the claimant wins. But if it does need to assess the validity of it, it can. And it does not, it's not a determination against the bank. It's a determination of whether the bank would have it's not a determination against the buyer. It's a determination of whether the bank could have conceivably decided that the acceptance act, as presented by the claimant, was valid. That's the determination that we're reaching here. We're not affecting the rights or even including the buyer.
Any rebuttal?
The respondent has 2 points for rebuttal. The first point is that the representative of the claimant has presented his position on incorporation of the arbitration clause disregarded the autonomous character, so that the sophisticated bank disregarded the provision and deviated from the provisions of UCP 600. However, we would like to refer this honorable tribunal to Article 1 of UCP, where it is stated that that the provisions of the UCP 600 are binding on all parties thereto unless expressly modified or excluded by the credit. So paragraph 10 is not express deviation from the provisions of the UCP 600, and therefore the position of the claimant is ungrounded. The second argument is that we consider that the claimant misled the tribunal by stating that it was bank who included paragraph 10 in the letter of credit. We submit that paragraph 10 was included by the claimant and not by the bank. And the bank just accepted this paragraph 10 and under UCP 600. The bank should only amend the instructions of the claimant in the current proceedings only in case when the provision is ambiguous and this and contradicts the nature of the letter of credit. And this is expressly stated in the International Standard of Banking Practice of the 2013 edition, paragraph 5.
Instructions given for the bank.
Yes.
Because the claimant is a seller.
Yes, instructions came from the buyer, not from the representative.
Okay.
Yes. I would like to make 2 brief points in the brief time that I have allotted. So, it means that there is no incorporation by reference in this case. Applying the language of Article 7.6 of the United Model Law, which states that says such to make that clause part of the contract, that's the standard. Combining that with the language of full effect in Article 10 of the letter of credit shows we submit the responding bank's intent to incorporate by reference the arbitration clause of the shipbuilding contract into the letter of credit. This thus makes Article 4A of the UCP inapplicable because as we submit, the bank has decided to deviate from its norms. I would draw the attention of the tribunal to Article 4B of the UCP 600, which states that an issuing bank should discourage any attempt by the applicant to include such references, and the bank in this case did so. And finally, the second point that I'd briefly like to submit is that it's not clear from the record who included the terms of Article 10 into the letter of credit, but what is clear here is that 2 parties in an arm's length transaction approved this, and one of them being a sophisticated party, which thanks.
Okay. Very good. Now I think we should start with the letter. Laura, you will start with the claimant.
Members of the tribunal, my name is Laura Townsend, and I will be presenting the seller's argument on the merits. The tribunal should not uphold the respondent bank's rejection issue in this dispute are governed by the UCP 600. One of the most important principles of the UCP is that letters of credit provide certainty of payment. To facilitate this, documents within a presentation are evaluated on their face. Banks do not look to or look for information outside of the documents themselves to make their determination. The day seller made its presentation, after reviewing the documents, the bank wrote that it was planning to fulfill its obligation to pay within the next 3 days. The bank then improperly solicited input from the buyer, who then wrote the bank demanding that payment not be made. It was only after these two events that the bank changed its position and decided not to honor its obligation to pay.
You said to illicitly solicit input from the buyer. Is there anything that prohibits the bank from contacting the buyer?
Contacting, no. Asking for its consideration or input on the documents, yes. There are a couple of scenarios where banks may approach the buyer. There are some national regulations, for example, in the United States regarding ongoing sanctions against Iran, where when a presentation is made or a demand for payment, then the applicant must be notified. Second, the UCP does give banks discretion to approach applicants for waivers of deficiencies in a presentation. However, the buyer did not approach the applicant for a waiver because it had not identified any deficiencies in the presentation when it wrote the buyer.
Your suggestion that the UCP positively prohibit contacts outside of those scenarios?
Expressly prohibits, no. However, those are the scenarios under which the UCP does envision that contact will be made because it is anticipated under Article 14 that documents will be evaluated on their face. The certainty of letter of credit is maintained because banks are not supposed to be investigators. They are supposed to fulfill payment once they receive documents that comply with the terms. The bank, it's clear, made a formally communicated determination to our client that the presentation is not complying, but that's not the end of the question. First, we know from UCP Article 5 that banks deal with documents and not performance. And from Article 8, that once a bank has decided that a presentation complies, it must honor. Now, we have evidence where the bank says it has reviewed the seller's presentation and is planning to fulfill payment. Based on these facts and the principles of review under the UCP,
Can you remind me the page of this letter?
yes, that letter is on page 29 of the record.
You are referring to the second paragraph, should review the outstanding.
Yes.
Does it actually say that they have already performed this review?
It says after a short review of the received documents that the bank is planning to honor the presentation. Based on this letter and the principles of the UCP already discussed, this is enough for this tribunal to find that the bank had made a positive determination on our client's presentation, which it is now bound to honor. Second, the official determination given by the bank is not valid. The bank only changed its plan to honor after consulting with a third party from whose account payment would be made. And the account holder wrote the bank that it should not fulfill payment. This external influence is not proper banking procedure for letters of credit. If the fourth tenet of on-their-face review has been violated, as it has in this case, the tribunal should not uphold the rejection.
How the fact that the bank approached this customer with this letter after affects your claim in this situation. Even if we find that bank was in breach or is in a situation, it should not avoid what it did approach the buyer. How it will affect, how it would help you in this proceedings.
If the bank had approached the buyer, letting the buyer know that the presentation had been made, planning to fulfill payment, and then the buyer did not respond, this would not be improper. However, in the third paragraph of the letter on page 29, the bank forwards a copy of the presentation for the buyer's consideration. It then does not either fulfill payment or otherwise contact our client until after it has received a letter from the buyer. This solicitation of input on the presentation is not allowed under the ICC 600.
That's fine. Even if you find that this was not allowed, as they did, how it supports your claim? Was that refusal to make payment was in breach of the letter?
We submit that our client was in the process, or the seller was in process of beginning payment to our client, but for its solicitation of input from the buyer and the letter from the buyer ordering the bank not to pay. Only after those two events did the bank decide not to fulfill its obligation to give payment to our client.
If we were to find that, I'm not assuming anything, that the signature is actually forged, would it still be your submission that the client is entitled to this liability?
Yes, I'll now address the issue of the signature. Neither side has evidence which unequivocally establishes who picked up a pen and signed the act of acceptance, but we submit that the act of acceptance is still valid. One, because it has a company seal, which clearly matches the one on the shipbuilding contract, which was added to the act after the signature on the act was already made, and whose authenticity is not contested. We have also provided this tribunal with additional evidence of the act's validity to assist it in reaching a conclusion. If you would please turn to page 51 of the record. You'll find testimony and newspaper articles showing that the buyer attended and participated in the acceptance ceremony for the yacht, and beginning with exhibit C14 on page 55, that the buyer and his wife have accepted and begun using the yacht. Now, respondent,
In terms of letter of credit, if the act of acceptance is forged, can we actually rely on this effective acceptance if, as you suggested, the bank should only be revoked?
two responses. First, we submit that the act of acceptance is not forged, and that the respondent's primary support that it is the demand from the buyer ordering the bank not to pay. Our evidence supports the conclusion that the buyer has accepted the yacht, both in usage and by his involvement in the acceptance ceremony where the act was signed.
But when we are dealing with a letter of credit that is paid against presentation of documents, should we be considering effective acceptance or acceptance by conduct, which is not active acceptance, which a letter of credit requires?
This tribunal can consider evidence of actual usage. The bank, when it evaluates documents on its face, only has the act of acceptance itself to look to. And when it first looked at the act of acceptance, it decided that the one that was presented, it did not raise any objections to the act as presented and made plans to begin payment.
In a hypothetical scenario, what meaning in your company? There's a lot of credit for the list of documents, which you were to submit to get payment from the letter of credit. And you go to your office, not your office, but somebody else, and use Photoshop. And by using Photoshop, you produce within 1 hour a set of documents which you carry from the LC. And then you present these documents to the bank. And the bank would ask its client, the buyer, whether the yacht was real and the buyer said no, and all the documents were approached. Is it your submission that even in such case, the buyer should make a payment? Because formally on its face value, they look like those who should be presented.
No. If there's clear and obvious evidence of fraud, the bank has the discretion to not fulfill payment. In cases of such an instance where either the items in the underlying transaction have not been delivered or different items have been delivered, the buyer is usually very proactive in reaching out to banks, letting them know that there has been fraud in the underlying transaction. Once the bank receives clear and obvious evidence of this fraud, it does have the discretion to deny payment. However, that is not the situation in our case. We submit that the act of acceptance is valid, that the yacht was delivered and accepted, and that therefore payment should not have been denied. With respect to the issue of the ship safety certificate, such a certificate was not required for payment. As my co-counsel has already argued, the letter of credit was issued with full effect to the shipbuilding contract. This is not a general reference, but a statement of how much weight the contract should be given if there are discrepancies between the contract and the letter of credit. The contract specified payment under the letter of credit would be made upon presentation of 5 documents, none of which was a ship safety certificate. These documents represent the complete understanding of the parties regarding payment. In addition to recognizing that a requirement of a ship safety certificate is outside the parties' understanding, and that our client relied on the buyer and the bank issuing the letter of credit, honoring the understanding that had been reached with the letter of credit and giving it full effect, this tribunal can and should give precedence to that intent. Further,
Isn't there an inconsistency in the argument? On the one hand, you're saying that the letter of credit is designed to create certainty, and that the bank's only obligation is to look at the documents. Here we have the letter of credit, a list of documents, one of which is very clearly stated to be the safety certificate.
yes, first, when the bank did receive our client's presentation, it did not identify such a problem. Second, the letter of credit is silent onto the content and origins of the ship safety certificate, and under the UCP, in such a circumstance, banks have the discretion to decide if a document or combination of documents fulfills the function of the required document. We respectfully submit that in this circumstance, that is what the bank did, as it did not object to the presentation at first on such grounds.
But you also accepted this letter of credit. Isn't that right? I mean, this was a very important part of the contract. It was half of the purchase price. Your clients accepted this letter of credit and proceeded to build the yacht.
Yes, we did. I see my time is about to expire, but I will elaborate if the tribunal will permit. We accepted this letter of credit as issued because of Article 10 of the letter of credit, which says that the shipbuilding contract and the understanding reflected therein would be given full effect. Therefore, we made a presentation relying on that understanding. Additionally, the bank is precluded from maintaining this and the previous objections to the documents before this tribunal. If a bank rejects the presentation under UCP Article 16, it must provide notice of its decision, its reasons, and what it's doing with the documents. As the bank did not provide notice of the status of the documents in its letter to the seller, it is precluded from maintaining that the presentation did not comply. Accordingly, this tribunal should award the remaining amount to the seller, along with the other requested relief. If there are any further questions, I'd be happy to address them at this time.
Thank you very much.
Honorable members of the tribunal, my name is Ekaterina Shkarbota, and I will proceed with presenting the argumentation of the respondent side, the GSC Trustee Bank, in this particular proceedings. And in my presentation, I will focus on the 4 issues that were raised by our opponents. That is, firstly, the compliance of the bank with the procedure of the review of the documents. Secondly, the improper signature on the Acceptance Act. Thirdly, the obligation of the seller to present the ship safety certificate. And the last issue concerning the proper notification that was given to the seller. So starting with the procedure of the review, I will ask the Honorable Tribunal to open the case material on the where we see the letter to the buyer from the bank. This is page 29, and here it is said that after a short review of the document, we are planning to honor the presentation. And the position of the respondent is that the short review at that particular moment has not taken place yet. And the bank was only planning to honor the presentation after it will review the documents. However, we also share the concern of the claimants that the sending of such a letter may pose a risk to the independence principle of the letters of credit. And it was underlined in the ICC publication, which is named as Leading Court Cases on the Letters of Credit, publication number 348. And there it was said that if such sending of a letter to the buyer may contradict the independence principle and make the bank to go outside of his powers of examination, this particular kind of review of the document is contradictory to the UCP 600. However, as we see from our case, the letter from the buyer have considered a lot of issues and reasons why the bank should not have honored the presentation, including the non-compliance of the seller with its obligation under the shipbuilding contract. However, we point to the fact that the only reasons that the bank has stated in its notice for refusal to pay is the non-compliance of the documents. And therefore, since the independence principle was not violated in this case, and the bank stayed within the powers which is given to you by the Article 5 of the Uniform Customs and Practice 600, the review was planned. If the Honorable Tribunal...
Can I ask you a hypothetical situation where we find that this approaching the buyer in this case was inappropriate in some way, what consequence would be?
In this particular case, the Honorable Tribunal may find that to some extent the bank has violated its obligations. However, we do not see any conclusion and any responsibility of the bank which follows from the violation of this review procedure. And therefore, even if there was a violation, this should not bring us to the conclusion that we have no right to claim the discrepancies. Moving to the question of the Acceptance Act, the claimant has correctly identified that the standard of examination of documents is the examination of the documents on their face, which is stipulated in the Article 14A of the UCP 600. And the Article D of the same, and the Paragraph D of the same article says that the document should comply not only with the UCP 600 and the letter of credit, but also with the other documents presented. And if I may, I would ask the Honorable Tribunal to open the case material on the page where we have the list of documents. It is the page 20. And here we see that the copy of the shipbuilding contract is also one of the documents to be presented. And if we review both the copy of the shipbuilding contract